Freedom of religion, key court cases. Zorach v. Clausen, 1952. This decision allows states to provide release time programs for their students because the programs took place away from public places. Engel v. Vitale, 1962. This decision struck down a New York State non-denominational prayer that stated with the words, "Almighty God, we acknowledge our dependence upon Thee." Abingdon School District v. Shem, 1963. This decision ruled that a Pennsylvania state law that allowed a Bible passage to be read at the start of the school day was unconstitutional. Epperson v. Arkansas, 1968. This decision struck down an Arkansas law forbidding the teaching of the theory of evolution. This case answered the questions raised in the famous Scopes monkey trial. In 1987, the Supreme Court further defined what can be taught in schools in Edwards v. Aguillard. This case ruled that Louisiana could not implement a policy that allowed schools to teach creationism as a religious doctrine, even if it was taught along with the theory of evolution. Lemon v. Kurtzman, 1971. The Lemon test, which came out of this case, sets the criteria in determining whether the line of governmental interference is crossed. The three-pronged standard indicates that the purpose of the legislation must be secular, not religious, that its primary effect must neither advance nor inhibit religion, and that it must avoid an excessive entanglement of religion with government. Even though this case struck down a law that provided governmental aid to private schools, it has been used as a barometer to measure other legislative practices of the state. Lee v. Wiseman, 1992. This decision directed school officials not to invite clergy to recite prayers at graduation ceremonies. Westside School District v. Mergens, 1990. The court decided, based on the Equal Access Act, that schools did not violate the Establishment Clause by allowing Bible study clubs to meet after school using school facilities where public funds were not being used to pay teachers acting as advisors to the club. The club also had to open its membership to students of all faiths. Santa Fe Independent School District v. Doe, 2000. A school policy permitting a student-led prayer before the start of a football game was ruled unconstitutional because the school provided the equipment.